Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3059, United States of America versus Kevin Johnson, appellant. Mr. Kramer for the appellant, Mr. Hobel for the appellate.
Good morning, counsel.
Morning.
Mr. Kramer, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. A.J. Kramer on behalf of Mr. Johnson. Your Honors, the First Step Act was signed and touted as a major reform in criminal justice and over-incarceration, particularly of people of color in the federal system. And there were two main provisions of it that received a lot of attention. One of those is the compassionate release provision. Mr. Johnson is in now 7 circuits have held that the guideline that existed before the First Step Act, 1B 1.13, is not binding on district courts. One, the 11th Circuit just recently held in a 2-to-1 opinion with a vigorous dissent differently. I know very similar issues were argued before this court in the David Long case, and I think Judge Pillard was on that panel. So obviously those issues are pending. There is, and that almost all of the issues were very similar with it, except with respect to the Winstead issue. But what you have here is a 60-year-old man, a black male with some serious health conditions who never should have been sentenced to the sentence he was sentenced to because he was not a career offender, according to this court's decision in Winstead. So that, in a number of courts, the government complained that, by the way, the government has not disputed that Mr. Johnson was improperly sentenced. It has never disputed that, although it says it hasn't agreed to it, or whatever that may mean. It's never disputed that he was improperly sentenced because one of his 2 prior convictions was an attempt. The district court in this case clearly believed it was bound by 1B 1.13 because it said at minimum, such reasons include at minimum those circumstances defined in the guidelines. So it also said or comparable or analogous. But it then went through Mr. Johnson's, without going to the Winstead issue, it went through Mr. Johnson's and evaluated them individually and dismissed them individually, but then never looked at the entire context of Mr. Johnson's situation. And of course, did not address the Winstead issue. And it's notable, I think, the government clearly thought the Winstead issue was raised because in its response, its opposition to the compassionate release motion, it raised the exact same arguments it raises before this court in the exact same manner, I should add, in a footnote that it raised before this court.
So one thing the government does argue with both issues, the Winstead issue and whether the policy statement is binding, is that the claims weren't raised before the district court. And so I know that you have arguments on both that they were raised, but if you just bear with the assumption that they weren't raised, then I didn't see an argument in your briefing that even if they weren't raised, that you still think that the claim should be heard by us and should be resolved in your client's favor under the plain error standard.
I'm sorry that obviously I guess it should have been, but I think it's so clear that they were raised by the district court referred twice, at least twice, to the fact of the cases Mr. Johnson cited and what they hold, and clearly understood that these issues are being raised, and it was specifically raised by Mr. Johnson that 1B 1.13 was not binding, that district courts had discretion to determine what are extraordinary and compelling. So, but I absolutely believe that it's plain error. When 7 circuits have held that it's that the guideline is not binding, and that the Winstead issue, which was just not even addressed by the district court, that clearly shows that he was improperly, he received a sentence more than twice as high as he should have received if he had been properly sentenced at the beginning. And if anything, his situation is worse than the defendant in Winstead because it was he was sentenced when the guidelines were mandatory, whereas Winstead was when they were advisory. But I absolutely think it's plain error if you
Mr.
read the statute.
Can you
sorry.
speak a little bit to the third and fourth prongs of the plain error review? I mean, if we assume we agree with, the other seven circuits that the error, that there's an error here, that's plain, can you speak to why it would also meet the third and fourth prongs of Olano?
Well, again, the government has not disputed, and the Supreme Court has said that when there's a guidelines error like this, it's almost always plain error because it affects the sentence. And I think the quotes at the end of my brief from the case Rosales-Morales show what the Supreme Court thinks about the integrity of the system when people are serving longer in prison than they should be. There's no dispute in the briefs or in the district court that his guideline range would have been 100 to 125 months as a non-career offender. That's less than half. So I think that when somebody receives a sentence more than twice as much as what they should have received, that the integrity and the fairness and the other two prongs, the last two prongs of the plain error analysis are clearly met.
Well, we're not directly here reviewing the sentencing, right? We're here reviewing the compassionate release motion.
No, that's absolutely right. And the government misstates the issue. I'm not claiming that the sentence is illegal, although it was, but the claim on compassionate release is it's an extraordinary and appalling circumstance that this court later decided that an attempt crime cannot be a basis for a career offender guideline. And so the government's misstated the issue. I'm not challenging the legality of the sentence. What I'm saying is it's an extraordinary and compelling circumstance when the sentence should have been less than half of what Mr. Johnson received. The case out of Rosales-Morales, this court says the public legitimacy of our justice system relies on procedures that are accurate, consistent, trustworthy, and fair. What citizen wouldn't bear a diminished view of the judicial process if courts refuse to correct obvious errors that threaten to require individuals to lean upon?
Do you think? Can I ask you? Do you think that it would be an error as a matter of law if the district court denied a compassionate release motion in this circumstance on the Winstead issue, or do you think the district court has is it in the district court's discretion to decide whether to take that into account?
If the district court could take it into, yes, I think it's, well, if you read the McKinney case didn't decide one way. The McKinney case said the district court said it can't be considered, and they said, no, you have to re-examine that. They didn't come right out and say it's there. They said since our laws changed and 1B 1.13 is not binding. I think to just dismiss it and say it's not a valid ground, if the district court said it's not a valid ground that I can consider as part of the analysis, I think that would be an error of law. If the district court said I've considered everything and I don't find this case so unusual or extraordinary or unusual, that would be a much closer case. But I think to say that can never be a reason in the calculus, I think would be a mistake.
So here,
I'm sorry.
Winstead is the argument you've really been focusing on, and it was, I would say, pretty tersely made in the district court, really mentioned only in setting up the context. Plus, Winstead is not categorically applicable to pre-decision cases. So isn't it the case that you have to sort of point out why Winstead should apply here, even though it's not categorically applicable to sentencing that preceded it? And what is it about this case, and what's the standard that we should use in determining whether the Winstead error should be recognized in this case, even though it isn't a categorically applicable rule to previous sentence?
I think a couple of things. There's a large number of 924C cases that have been deemed applicable that courts can reduce sentences because of the stacking of 924C, which was done away with in the First Step Act. If anything, that would be a stronger case for not applying it because Congress chose not to make that retroactive. Winstead, of course, is a court decision that means from the beginning that guideline was invalid in having attempted drug crimes included. So I don't think what I'm asking for is that it be made retroactive. I'm not asking that at all, although the government seems to be saying that. What I'm saying is it can be a factor taken into account of whether there's an extraordinary and unusual circumstance because, and that's exactly what the court in McKinney said, that the district court had to examine it to take that into account because it's, again, I'm just repeating, I mean, he received a sentence twice as high. I'm not asking that Winstead be made retroactive. That's not what I'm asking. All I'm asking is that it be taken into account as the extraordinary and unusual circumstances in combination, I might add, with all the other circumstances, including that quite extraordinary fact that in almost 19 years in prison, he's had one very minor disciplinary infraction.
But you're not making the argument that on the Winstead issue that it would be an error as a matter of law to deny a compassionate release motion that would have the effect of sentencing the individual as if he were sentenced in a time when Winstead was the governing law. So because if that was the argument, then it would be effectively equivalent to saying it's retroactive.
Right. I have never made the argument that the district court has to do this. The district court, obviously, for whatever reason, didn't. And I understand, Judge Pillard, that it was terse, but it was it said notably there's a Winstead issue. He was a career offender and had his sentence enhanced, but had he not been a career offender under Winstead, his sentence would have been 100 to 125 months. I mean, it was made, and then the cases that are listed at the back, one of them was clearly a case about Decatur on page, I think it's page 88 of the appendix, was a case about a sentence too high. The other cases, recent cases, Mile was another case where the sentence court said you can take into account that the sentence was higher than it would have been now.
So what's the standard for us in reviewing, or maybe I really have two questions. How should a district court, in looking at the Winstead question, sort a case in which it shouldn't disturb the sentence from a case in which it should?
Well, I think that's not a question you have to answer because the district court didn't address it at all in this particular case. So all I've asked is a remand for the district court to consider all the arguments under, first of all, that 1B1.3 is not binding. That's the threshold issue. But to consider all the arguments under the proper interpretation of 1B1.13, including the Winstead issue, to consider that issue. I don't think you have to set forth.
I'm not proposing to set forth a standard, but I'm trying to think through how we evaluate what you're claiming was an error on the part of the district court, and trying to get at that by asking if the district court considered it correctly, what would that look like to compare what it did with what you think it should have done? And what I'm hearing you say is that it should have considered all the factors together, that potentially bear on compassionate release. But I'm particularly trying to understand how it would look at. So because you answered Judge Srinivasan that it wouldn't be an error as a matter of law for the district court to deny the Winstead compassionate release under these circumstances, I'm trying to understand where you see the district court's discretion, where and how that should appropriately work on remands.
I think, let me give you some examples, maybe. A district court could say, you got to remember, in this particular case, he had two prior felony drug convictions, both involving a $10 sale of drugs. Now, they could have been huge drug sales of kilograms, multi-kilograms, and the district court could have said, well, even though one of them's an attempt, they both involve huge quantities of drugs. and you were a kingpin, and the career offender, even though technically doesn't apply, you were a kingpin and deserve it. I think that might be appropriate. I think that the district court could say you have 8 other felony convictions, which of course Mr. Johnson only has misdemeanor convictions. You have 8 other felony convictions, including crimes of violence, which may not have counted towards the career offender, but I'm going to do that. The district court could have said, your range, you have 20 disciplinary violations in the past 2 years. So I think the fact that you were incorrectly said. So there could be a whole host. The problem in this case, of course, is that the district court didn't address it at all. So I think there could be reasons. There could be, obviously, I think Mr. Johnson's case clearly qualifies for the consideration that it's extraordinary, unusual, but there could be cases where it's not for whatever reason. But Mr. Johnson's is quite stark. He has 2 $10 drug sales. One was an attempt, and one was an attempt, and they increased as a result. He got more than twice as much on the low end of the guidelines than he would have been if he had been properly sentenced at the time. So I hope that answers your question. I think
helpful. Thank you.
Thank you. Unless my colleagues have further questions for you at this time, we'll hear from the government and we'll give you some time for rebuttal.
Thank you, Your Honor.
Mr. Hobel.
Thank you. May it please the court, Mark Hobel for the United States. The district court did not treat the policy statement as binding. It treated the policy statement as helpful guidance, but also recognized that there might be an expanded set of circumstances that could be extraordinary and compelling. That's not error under any standard of review in any circuit that has looked at this issue. And it's also what the defendant asked the district court to do.
So the government made the argument that the policy statement was binding, right, to the district court?
I believe in a footnote, yes. I think the defendant said apply the criteria in the policy statement. The government said, yes, we agree, and included a footnote that indicated that it remains binding, although it mentions, the language of the policy statement is upon motion of the BOP director. And the district court recognized that it needed to start with the policy statement as guidance, a frame of reference, but that it also recognized there could be. It gave the defendant sort of the benefit of the doubt on this question, and said,
well, I guess what would be surprising to me a little bit is that if the government made the argument, which I think the government did, that the policy statement is binding, if the district court actually thought it wasn't binding, I guess I would have expected the district court to reject the government's argument. And I didn't see that. I think there is some language, I grant you, there's some language in the district court's opinion that you could look at and say, well, he said at a minimum, and at a minimum, I mean, in some ways can cut in either direction here. I understand why both sides are using that language. And there's the language about we're going to take into account, there's decisions that have taken into account analogous circumstances. I'm not sure that necessarily means the policy statement isn't binding either. It could just mean the policy statement is binding, but the policy statement allows for taking into account analogous circumstances. I guess what would be a little bit surprising to me is if the government agreed that the policy statement is binding, that the district court would have thought it wasn't without saying so, without saying I'm rejecting the government's argument that the policy statement is binding.
I agree with Your Honor that if this was a hotly contested issue and the parties had taken opposing positions on whether the policy statement is binding, you'd expect the district court to address it more fulsomely. But that's not what happened. But then
he would be rejecting both of your arguments. I mean, I don't know how that helps. I'm not sure I understand how that helps you, because if you're saying that both parties were operating on the assumption that the policy statement is binding, then all the more surprising that the district court wouldn't have said, I disagree with both parties.
And again, I think it just goes back to this was not an issue that the defendant, despite the fact that there were plenty of district court opinions at this point that addressed this issue, that the defendant made an issue. I think
that's the plain error argument. That I understand. That's the argument that the defendant didn't flag it and therefore plain error applies, which is, I think, a different argument that I've been saying that the district court never thought it was bound to begin with.
Right. Well, I think that our bound to begin with argument just is based on the plain language of the district court's opinion, which is that it recognized that it quoted explicitly to a case, United States v. Fox from the District of Maine, which itself, and we noted this in our brief, itself says the policy statement is not binding, but is helpful guidance. It said there is a more expansive set of circumstances beyond just the specifics of the policy statement they could look at. But even under that more expansive set of circumstances, the defendant's medical conditions in COVID-19 don't qualify as extraordinary and compelling. So I think just based on a plain read of the district court's opinion, it's using the policy statement as guidance, but not as binding. And I know that the defendant has pointed to the use of minimum. And I think that the way to read minimum in there plainly is that the district court felt that extraordinary, compelling reasons for a sentence reduction were at a minimum those in the policy statement, but could include others not specifically enumerated there. Start with the frame of reference of the policy statement. Think more expansively, especially in light of COVID-19, which is not something that the policy statement writers anticipated. But
Mr. Hochul, what do you make of the district court's failure to address the Winstead argument? I mean, one reason might be that it wasn't clearly enough raised, so we would review that for clear error only, for plain error only. And the other might be that it would only fall in the catch-all provision, and if the policy statement were binding and it wasn't something identified by the Bureau of Prisons, it would be off the table for that reason. What's your view of why the district court didn't get there?
I think both of those propositions are true, Your Honor. I think why the district court didn't get there is because it wasn't raised. It was, Your Honor referred to it as terse. I think respectfully that's even overstates it. It is a mention of the quote Winstead issue in the defendant's statement of facts. There's no mention of it in the argument section. There isn't even a mention of it in his discussion of the 3553A factors, which is where you'd expect something like the length of his sentence and the fact that if he'd been sentenced after Winstead, he would not have been sentenced as a career offender. You would expect that to be in there. There wasn't even any discussion in the 3553A factors. So, I'd point the court actually to Mr. Kramer in his 28J letter earlier this week cited to the Seventh Circuit's recent decision in United States v. Newton. And in that case, the Seventh Circuit said, at a minimum, the district court's analysis must give us reasonable assurance that it at least considered the prisoner's principal arguments. This wasn't a principal argument that he raised. This wasn't an argument that he raised at all. He touched on it in passing. The government responded to it in a footnote in the section of our brief dealing with the 3553A factors, indicating that the government certainly wasn't aware on notice that as he now claims, it was an extraordinary and compelling reason. I think I think to a certain extent, the defendant is recasting his claim before this court. That may be, he is not challenging the factual determination that the district court made that his medical conditions do not reach the standard of extraordinary and compelling reasons, especially in light of the fact that he's now been vaccinated. And he is trying to raise this Winstead claim for the first time here without really grappling with the hard questions about that I think that this court has raised. I think at some point, Mr. Kramer said you can send that, you don't need to address the issue of when a defendant is entitled to relief under Winstead. I think this is...
Mr. Holden, can I ask you, if we were to agree with the other circuits that the policy statement here isn't binding, and we also thought the district court was at least unclear about whether it considered itself bound, in those circumstances, and I understand you don't agree with that, but in those circumstances, would we need to remand?
No, and I think that this goes to Your Honor's question to my opponent on the third and fourth prongs of plain error. There really hasn't been a showing here of actual prejudice or that this undermines the integrity of the proceedings. I mean, maybe most most fundamentally, when it comes to those prongs, this is the law that the defendant asked the court to apply. The very first argument in his motion, if you look at his compassionate release motion, the very first legal argument he makes is, I satisfy the policy statement criteria.
Well, but that's not about prejudice and also the fourth prong. So maybe speak to those questions.
Right. I think it is his burden to show that if the district court had not treated the policy statement as binding, there's a reasonable probability of a different outcome here. I think given the district court's discussion of his medical conditions, and the district court didn't, in its discussion of his medical conditions, it doesn't refer back to the policy statement. It consistently says, and we make this point in our brief, it consistently says that those don't satisfy extraordinary and compelling reasons under the statute. So it compares it compared Johnson's conditions to other defendants who have received compassionate release under sort of a holistic cumulative standard that the defendant is saying the court didn't do. Compared it holistically to other defendants during the COVID-19 pandemic, and said these conditions don't rise to that level. So I think that if you take I think that the defendant just hasn't shown that if the district court had more clarity that no, the policy statement really isn't binding, although you can still look at it for guidance, that it would have come to a different outcome on his medical condition.
Can I ask the question this way? So suppose the district court says, I'm just giving you a hypothetical, I'm not saying this is what the district court said, but suppose what the district court said in a case like this is, I have a motion before me for compassionate release. I understand that it raises some questions about the medical conditions of the movement, and I understand that there's a Winstead claim before me. I don't have to consider either of those because the policy statement is binding, and neither of those states a ground for relief under the policy statement. So therefore, I'm denying the motion under the policy statement. And then if it comes up on appeal and we say, per the 7 other circuits, it's actually not binding, then what happens on prongs 3 and 4? And I'm assuming the claim wasn't raised that it's not binding in the district court. Then what happens on prongs 3 and 4 when the district court has said, the reason I'm denying relief is because the policy statement is binding? It turns out that's wrong. Okay. And the district court just has said, I'm not saying what's going to happen if the policy statement weren't binding. I might have granted relief, I might not have.
Okay. It's still, I understand the question. It's still his burden to show that there's a reasonable probability that his compassionate release motion actually would have been granted. So there may be facts that say the district court may have made comments to the effect of, I think this sentence, I think you're a good candidate, but the policy statement just prevents me from doing it. I think in that case, in that hypothetical, you'd have a pretty good argument on prongs 3 or 4. I think
what about is it Mendoza-Martinez, where we say a guideline error, and I understand that's a calculation of length, but a guideline error is presumptively prejudicial, except in extraordinary circumstances.
Right. So I think when you're talking about, and I think Your Honor may be talking about the actual sentencing context as opposed to compassionate release. And in sentencing, because of the roles that the guidelines play of orienting, is the very start of the process to give the guidelines range. If you're get sentenced at the midpoint of the guidelines range, and it turns out that it's the wrong guidelines range and it should have been down here, there's sort of this, the Supreme Court has said there's sort of this presumption that you probably would have been midpoint of the lower guidelines range. I don't think that I don't think that this situation is analogous, because I think there are I don't think the presumption applies in the same way. I think that the defendant still has to make some showing that there is some reasonable probability of a different outcome here. So I see my time has expired, so we'd ask the court to affirm the district court. Thank you, Your Honor.
Thank you, Mr. Hobel. Mr. Kramer, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. A few things. First of all, despite having the entire time to argue, they have never disputed that Mr. Johnson was improperly sentenced as a career offender. So they've essentially, well, not admitting it, they have not challenged that. If you look at page 91 of the appendix, after citing about 25 or 30 cases saying that the district courts had broad discretion, Mr. Johnson said, as these cases illustrates, now the courts are no longer constrained by the BOP's narrow interpretation of extraordinary and compelling reasons. They have embraced their broad discretion under 3582 to grant compassionate release. Again, it seems to me he clearly raised the issue, and we don't have to talk about plain error. But even if the district court had considered the fact of the medical issues and the fact that his sentence was more than twice as much as was required under the mandatory guidelines, there clearly is a good chance the district court would have granted the motion for compassionate release under all the circumstances. You can't.
Mr. Kramer, I should have asked this of Mr. Hobel as well. Can an incarcerated individual bring more than one motion for compassionate release? So, and this might bear on the question of preservation. Is there anything to prevent him from coming back to the district court and saying, oh, I didn't really explain exactly what I meant. Look at this Winstead problem.
No, there is not anything to prevent him. As far as I know, you can make one a day or more. But the problem is the procedural mechanism that it has to be, you have to wait 30 days after you present it. So you get a built-in delay unless a defendant submits a request daily. I guess you get a built-in delay of 30 days. That's the problem. But there is not a limit in the law about how many can be filed. By the way, the government...
Do you mind if I just confirm with Mr. Hobel if he agrees? I should have asked that before.
Sure.
Is that right that there isn't any bar on bringing an additional motion for compassionate release if the individual...
That's correct. The exhaustion requirement still applies, but there's no second or successive bar.
Thank you.
The only other things I wanted to say was the government talks about how they responded to the Winstead argument. It was almost identical about how they responded to it in their brief, even though it was raised fully in the briefs. They did a short footnote saying it can't be considered at all in compassionate release. And then lastly, they said, although it's not part of the record, that Mr. Johnson has been vaccinated. But I opened my sports section today and saw that 8 members of the Yankees who have been fully vaccinated have come down with COVID. Well, I feel bad for them as individuals. I don't feel bad for them as the Yankees. But clearly the fact that people have been vaccinated is not as 8 members of a professional sports team that come down with COVID that tested positive. It's not, and in any event, it would be something for the district court to consider on remand, that issue. But I would ask Your Honor to remand it, first of all, on the 1B1.13 issue, and absolutely remand for consideration of the Winstead issue that was raised. They said that his sentence would have been substantially less, and now I'm just repeating myself, and I apologize. But thank you very much.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 18-1258 et al. Iowa Network Services, Inc., doing business as Aureon Network Services, Petitioner, versus Federal Communications Commission and United States of America. Mr. Troop for the Petitioner, Iowa Network Services. Mr. Hunsutter for the Petitioner, AT&T Services, Inc. Mr. Sher for the respondent.
Morning, counsel. Mr. Troop, please proceed when you're ready.
Good morning. May it please the court. My name is James Troop. I represent Iowa Network Services, doing business as Aureon Network Services. Aureon filed a tariff enforcement action against AT&T in Federal District Court in New Jersey. It seeks enforcement of the effective state and federal tariff rates. The complaint seeks enforcement of the Section 203 of the Communications Act and the state statutes in Iowa and Nebraska that codify the filed rate doctrine. The FCC accepted a primary jurisdiction referral from the district court regarding those referred statutory questions, and now AT&T and the FCC have raised numerous procedural arguments asking this court to not reach the merits of the statutory issues. It would be a mockery of the primary jurisdiction doctrine if this case goes back to district court without any resolution of the statutory issues. That would leave the district court in the same place it was 6 years ago when this referral proceeding began. We ask that this court, in the spirit of judicial efficiency, to send a clear message to the district court that the rates that AT&T should pay for Aureon services are the effective state and federal tariff rates.
So can I start you off by asking about the filing that the parties made last night, where there's an indication in a document filed by you and by AT&T that the parties have reached an agreement in principle? And I just want to know, what does that entail for our review of the case before we get into the issues that you are about to get into?
Well, at this point, this case needs to proceed until there's an actual final settlement agreement. I only learned about the settlement negotiations with AT&T last night. There would need to be an agreement with the FCC as well.
What I'm confused, maybe I'm misunderstanding the context. You only learned about the negotiations last night? I thought, aren't you involved in them?
I was not involved in the settlement negotiations. No, I was told last night that there had been progress with AT&T. I understand there's been no discussions with the FCC so far, but...
Do you mean other counsel for Iowa Network Services was responsible for talking with AT&T and FCC on the settlement side?
I believe maybe local counsel may have been involved. My understanding is...
Wait, so you're standing up, you're representing the client that's the party that's before our court, and the parties have filed a document with us saying that they've reached an agreement in principle, and you're not in a position to say anything about it, even though you represent that party?
No, Your Honor, I have seen the emails back and forth. I was shown them last night that showed that they have reached some of the terms. The Aureon board has not looked at these terms. I think it's preliminary at best. The FCC would need to agree that...
Well, we can talk to the FCC. I understand that, but I guess I'm surprised by the fact that parties would have filed a document in our court representing that there's been an agreement reached in principle, and that then the parties representatives before us are not in a position to tell us whether there's been an agreement reached. I mean, you're making it sound like there actually hasn't been an agreement reached because it hasn't gone through the necessary layers or something, and certain people who represent the parties before us aren't aware of what's going on.
No, I saw the emails going back and forth that showed that there was discussions and negotiations, and that the parties had reached some agreement on terms, but the Aureon Board of Directors has not seen any of this. And so I think at this point it would be premature. There's been no written settlement agreement.
Okay.
And in order to have a settlement of this case, which impacts the tariff rates that apply to all carriers that use Aureon services, there would need to be an agreement with the FCC as well, because Aureon would need to earn the minimum rate of return to remain in business, the minimum rate of return prescribed by the FCC, regardless of foregoing carrier benchmarking to remain in business. We need some agreement regarding the future impact of rates and the rates that apply to all other carriers before we could dismiss this case.
If there were such a settlement reached, then Aureon would seek to dismiss its petition for review. Is that correct?
if Aureon could reach an agreement with both AT&T and the FCC, then there would be a position to dismiss the petition for review here. Otherwise, if it's just a settlement with AT&T, I think it would be a dismissal of just the district court case in New Jersey. So the filed rate doctrine controls this case. Maisland says that the tariff rate is the only legal rate, and regardless of any contrary FCC rule, the tariff controls.
Mr. Troop, can you respond at the outset to AT&T's challenges to Aureon's standing? How do the not yet final decisions that are being challenged, the first and second order, have a concrete effect on Aureon?
Well, the orders ordered Aureon to change its rates. Before it had been ordered to change its rates, it had protection from retroactive refunds. Both these tariff orders say that the rates are unlawful, even though the SEC allowed the rates to remain effective until compliance filing.
But my understanding is that Aureon hasn't challenged the aspect of the orders that sent them back for Aureon to further substantiate its cost calculations. And so if that part isn't challenged, then the filed rate is not the filed rate. It's pending further substantiation by Aureon. And until that rate is determined, it's not clear whether that rate applies or whether the benchmark rate applies, because one doesn't know which is lower. So it's just not clear what the concrete effect is on Aureon. And your briefing focuses a great deal on, well, now you have to do this compliance, but the compliance that you're pointing to is with an aspect of the order that I don't see being challenged.
The tariff rates the SEC allowed those tariff rates to remain effective. So under the filed rate doctrines, they have to be lawful. Under Section 203 of the Communications Act, Aureon would face penalties if it charged any rate other than the effective tariff rate. This court faced a similar situation in an MCI case, which I can find a site for. But this court can redress the harm by removing the designation of unlawfulness that is in the ordering clauses of these two orders, because that rate cannot be unlawful if it is the effective tariff rate.
Can I just, I may be just re-asking what Judge Pillar asked, but I just want to make sure I understand the context. We don't know yet for the relevant period. I know that there's been a subsequent rate post-2019, but the period that's at issue in this case is, I think, spans 2018 to 2019. And as I understand the factual context, we don't know yet whether the governing rate is the benchmark rate or the cost-based rate, because it's only the lower of the two that's operative. And if all your challenges are to the benchmark rate, then we don't know yet whether any of those challenges even matter, because the benchmark rate might not even be the operative rate if the cost-based rate's the operative rate. And if that's the case, if we don't even know whether the challenges you're making are to a rate that's operative, then that starts to sound like something as to which we don't have standing, because we may be addressing something that turns out to be a non-issue.
The only, during 2018 and 2019, the only operative rate is the effective tariff rates, both in the state tariffs and the federal tariffs. Under Maisland, the filed rate doctrine is strict. There's only one legal rate, and that's the effective tariff rate, regardless of the lack of cost data. That's
your argument on the merits, as I understand it, that the filed rate doctrine means that the rate that you submitted is the operative one. But I think that's your ultimate merits argument on that issue. But isn't there an antecedent question about whether, under the FCC's orders, the benchmark rate or the cost-based rate is the lower one, because the lower one is the one that governs? And unless we know which one the lower one is, then we don't know whether the challenge is even in a ripe state for purposes of either ripeness doctrine or standing doctrine, because we may be addressing a challenge to a non-governing rate.
What, in our judicial system, something is not unlawful if there's a lack of evidence in the record to determine unlawfulness. Here, the SEC found there's insufficient data to make a determination of what is the just and reasonable rate or what is an unlawful rate. So they allowed the tariff rate to remain effective, and that is now.
But isn't it, it's Aureon's burden to justify the rate. And so to that extent, there isn't a lawful rate unless and until Aureon either persuades FCC that it's wrong to require additional evidence, but there was no issue taken with those aspects of the order. So that is an avenue that's foreclosed. Or Aureon supplies the missing information. So right now, rather than there being a presumptively valid rate in effect, it seems like there is a presumptively unsupported cost-based rate. And in 2020, this court held that Aureon may be subjected to the transition rules, including the benchmark rate. And that's not open to us to disagree with here.
Well, I think you look at this court faced a similar situation, MCI versus FCC, 627 F2D 322 at 338. In that case, AT&T's rates, the FCC found were not supported by sufficient data, that the AT&T rates were allowed to remain ineffective. In that case, also the FCC said that rate was unlawful. This court in that case said the effective tariff rates at the time were the lawful rates and were enforceable, and that the statute had to have, I think the court used the word, some flexibility in the joints to allow for the effective tariff rates to apply until there was a compliance filing. And that's consistent with Naslin and the filed rate doctrine, because there has to be an effective rate, and this court can redress the injury of the FCC calling this rate unlawful by removing the exposure to retroactive refunds, and to ensure that Aureon can earn the minimum rate of return that was prescribed by the FCC. The FCC has the burden of proof under Section 205 to show that this benchmark rate is just and reasonable, because Aureon did not, in its tariff filing, propose any kind of rate benchmark. That the proponent was the FCC. This lower than interpretive rule is no binding legal force because it's just an interpretive rule, and Section 205 uses the word shall. You shall be able to earn the minimum prescribed rate of return, and the benchmark rate violates Section 205 on its face because it doesn't allow Aureon absolutely to earn the minimum rate of return if it's above the benchmark rate.
Okay, let me make sure my colleagues don't have additional questions for you at this time. Yes, please.
I had one other question. Mr. True, can you explain, did Aureon raise those claims before the FCC?
Yeah.
These claims under 2B, 203C, and 205.
Yes, we did, and in AT&T's meritless preclusion argument, they over and over say all the ways that we raised.
Now, I'm not asking about preclusion. I'm asking about exhaustion under 405, 405A.
Yes, I'm just saying that AT&T's preclusion argument lists all the ways that we raised the statutory arguments and all the opportunity the SC had to consider them. In this case, we are, as an applied statutory challenge, we're saying that the referral order in 2017 was an incorrect rule of law. They're applying that incorrect rule of law here, and the FCC certainly had the chance to pass upon its own rationale in the referral order. And this is also not the type of proceeding where exhaustion even applies. It's an investigation. It's not the judicial model. Aureon did not designate the issues. The FCC chose the issues. There's an interpretive rule like the Flight Now case. Exhaustion doesn't apply to interpretive type rules like the lower than interpretive rule. And the FCC had the burden of proof under Section 205 to show that the foreborn carrier benchmarking resulted in at least earning the minimum rate of return.
Okay. Let me ask my colleagues if they have any additional questions for you at this time. Okay, thank you, Mr. True. Mr. Honsetter.
Good morning, and may it please the court. I'm Michael Hunsetter, representing AT&T. Obviously, we're here as a petitioner, and I was going to start with AT&T's petition. I don't know if the court does have questions about the settlement and the fine, and happy to address those.
Well, I'm just curious as to your perspective on it, given that there's been a document filed with us that says there's been an agreement in principle, and of course, we're interested in knowing about that to inform our further consideration of the case.
No, that's correct. And so I became aware of the settlement negotiations earlier this week. And then yesterday I saw an email between my client's, negotiator, authorized representative, and Aureon CEO, and it said there was an agreement in principle. We have an agreement in principle. It's a term sheet of some kind. It's not a final written settlement agreement, and that has to be executed. But under the guidebook, the DC Circuit's handbook, we were under the view that we should notify the court as soon as there was a settlement in principle reached, and so we did.
I appreciate that, and I guess my question is your understanding of the agreement in principle one that would end the case?
I think it would. It would end all the litigation, and indeed, I think the condition in the term sheet is that these three petitions for review would be dismissed by the parties because we're the petitioners. Obviously, the FCC's party, other people are parties, they could potentially object, but it's our two petitions, and I think the agreement in principle does call for them to be dismissed once there's a final written agreement. I hope that.
So if the agreement in principle ripens into a final agreement, then your understanding is then the parties would move for a dismissal of their own petitions and thereby ending the matter before us.
That is
assuming there's no complication with the commission.
That's absolutely correct, Jerome.
Okay.
Thank you. So I would like to turn.
I don't know if you're at liberty to say this, but just a clarification, and just tell me if you aren't. But the settlement in principle would not turn on FCC approval or agreement to act.
Not that I'm aware of. I don't believe so, but I did not ask to investigate that specific question, but I don't believe that's the case. Is that helpful?
That is.
Thank you.
All right. So I'd like to turn to our petition in the case below. And I think in the case below, the FCC properly rejected two of Arion's proposed tariff rates and really reined back in a carrier that was failing to heed to either of the FCC's rate rules. Arion's rates would have continued unreasonable charges that had been going on for several years, since at least 2013. And those rates were being levied on enormous volumes of traffic associated with an anti-consumer scheme that the FCC refers to as access stimulation. However, when it came to calculating the benchmark rate cap that was applicable to Aureon, the FCC let Aureon off too easily. Because the FCC's rate calculation violates the text as well as the purposes of the rule, Section 3C of the FCC's first rate order should be vacated. And let me turn right now to the text of the benchmark rule. It provides that the benchmark rate is the rate, quote, charged by the competing ILEC. Competing ILEC is CenturyLink. And on its very face, and this is in JA 559, the FCC's order shows that its rate calculation is not a rate charged by CenturyLink. It's instead a hybrid rate. It has some CenturyLink rates, but in fact, the largest component consists of an Aureon rate. And if you look at Table 1, which is paragraph 43 of the first rate order, it's JA 559. The FCC lays out in a table its composite rate benchmark. And if you look at the line that says per mile, I can pause to make sure your honors are at the page. But if you look at the per mile line, which is I think the third line in the column, the FCC calculated a rate for that particular rate element of about 0.003. That's not what CenturyLink would charge on these calls at issue. It's rather what Aureon would charge because only Aureon is carrying the calls 103 miles. The evidence before the commission was undisputed that CenturyLink, the competing ILEC, would provide at most 22 miles of transport. And you can see that in paragraph 20 of the FCC's reconsideration order, where they basically concede that the evidence did in fact show that CenturyLink would carry at 22 miles.
Mr. Hunsader, it's the .00003 is CenturyLink. It's the 103.519 miles. That's Aureon.
Well, I think what I'm saying is
per mile from CenturyLink. Am I right?
So the
price
second
per mile
column,
is the CenturyLink, and then it's the time. It's the multiplier distance that's Aureon's. It's just a question of fact.
So, yeah, just a question of fact. So the second column, that's, you know, those are all rates drawn from CenturyLink's tariff. There's no dispute. And then that third column, which has the 103 miles, that's Aureon.
Right. Okay.
Mileage.
Yep.
And then they multiply that together to get the .003 rate, which we think is this impermissible hybrid rate. And so because the rules require a benchmark to the rate charged by CenturyLink, the text of the rule requires the FCC to use CenturyLink's miles, 22 or less, to calculate the composite rate. And instead, it used this hybrid mismatch to come up with a rate of 003106 for that particular rate element. The FCC's argument is that AT&T is conflating rates with charges. But Table 1 shows that the mileage, right there in the table, is part of the composite rate. It's not some separate charge that's applied after the fact or some other service that we're purchasing. It's part and parcel of the composite rate that the FCC itself calculated. So we haven't conflated rates and charges at all. The FCC's calculation is also inconsistent with the definition of rate in the rules. And the definition of rate provides that the benchmark rate is a composite rate of all applicable charges, and it's expressed on a per minute basis. There's two primary inconsistencies with the text of the rule here. One, this underscores that as to the rule's prior reference to the rate charged by the competing ILEC, this ILEC rate includes the composite of all its charges, and thus would include the rate for CenturyLink's miles, which are 22 or less. Second, this definition means, as a tautology, the two carriers' rates need to be equal on a per minute basis. But what the FCC did here, as shown in Table 1, is to equate the two carriers' rates on a per mile basis. As explained in our brief, it's indisputable that on any two calls that are the same duration, 1 minute, 10 minutes, an hour, the rate that Aureon charges cannot exceed the CenturyLink rate for that same call. That's the relevant inquiry, and that's the benchmark rate that AT&T put into the record. But the FCC acted inconsistently with the text by examining and equating what both carriers would charge for 103 miles of service. That's exactly what Table 1 shows. And if the question were, well, what if both carriers charge for 103 miles? As Judge Cohen said, it's a matter of math. It's right there. But that's not the relevant question. The relevant question is, what would CenturyLink charge for its services, which are, again, the tandem switching and transport services at issue?
Okay,
I see my time is up.
Yeah, can I just ask you one question on this, which is, this all concerns the benchmark rate, right?
That's correct.
And so
none of our arguments concern the cost of service. Is that what you're asking?
Well, I thought you did have an argument that concerns the cost of service. It's just not.
No, I meant none of our first argument. We do have a bypass argument.
Exactly.
I'm sorry.
So I guess my question is this: that as I understand your position, you say that Aureon doesn't have standing in your response brief to Aureon's because we don't know yet whether the benchmark rate or the cost-based rate is the governing rate. This challenge of yours is to the benchmark rate, then you've got your other bypass argument as a challenge to the cost of service rate. But why aren't you subject to the same objection, which is we don't know which of the rates is governing, and therefore there's not standing to go forward on either of your arguments because the same problem?
Yeah, let me address, I do think for us, I think the reason we have standing is, again, right now the tariff rate is 0.4 cents or thereabouts. And again, under our benchmark calculation, if it had been accepted, the benchmark would be 0.3 cents or even lower. So I think that gives us standing, because right now we're being charged 0.4 cents.
And that's, you're being charged that rate, just so I understand the factual context. That's not on a going forward basis after 2019. You're talking about the rate that was in effect for the relevant period for purposes of these challenges, which spans 2018 to 2019?
No, I actually am talking right now. And I guess the one thing to get back, I just want to make sure that I answered the question on standing, that I think how we're injured today standing here, because right now we're being charged 0.4 and we should be charged a benchmark rate. But I guess the one thing that I sort of quibble with in terms of how the courts presented it, the way I understand these Section 204 proceedings is that the FCC makes a determination, and they say that for this period from 2018 to whenever the INS filed or Aureon filed a new tariff, and that's kind of over. The rate's been declared unlawful. If you look at the end of the first rate order, that's what it says. Now, the FCC is going to have to conduct more proceedings or approve some kind of refund plan to figure out what customers that paid the tariff rate during the period from beginning in 2018 to whenever that tariff was superseded. You know, we're going to be entitled, and other customers are going to be entitled to refunds. But it's over in the sense that, you know, they're not, for that period, they did not justify that rate under the cost of service. And that's why I think we're saying there's no standing. I think we agree with everything the court said, but I think it's all the more reason that there's no standing, because you can make a ruling and rule in favor of Arya. That tariff from 2018 to whenever it was superseded is going to remain rejected, because they're not challenging any of the cost of service basis on which it was rejected. So that's our standing argument. I think it's somewhat even more forceful than the way, frankly, the court has presented it, based on my understanding of the Section 204 procedures and how they work.
And that same objection doesn't apply to you, because is it because you're challenging aspects of each of the separate prongs? And so if we assume you prevail on the merits of both, which is the sort of provisional perspective we take in assessing standing, you have challenges to either. And so one way or another, this case affects you going forward? I mean, not going forward, it's charged in the future, but it affects how the appropriate rate will be calculated and the nature of a refund.
I think that's right, Your Honor, essentially. I do think that both arguments affect. That said, I think we would have standing under either argument separately, but I do think that you're correct that, again, if the FCC had ruled in our favor, then we would have had a determination that the benchmark rate was 0.3 or less, possibly. And again, that is causing, the fact that they did not make that determination is injuring us right now.
Right. Even if you only were charging the benchmark, some aspect of the benchmark rate, and not challenging anything to do with the cost-based rate, the fact that your theory would bring the benchmark rate in below the cost-based rate would entitle you to a bigger refund, because it would be below the rate that they collected.
It would be a bigger refund, and right today, we would be being billed less access charges, and we would be paying less access charges, and that clearly, I think, is injuring that.
But how do we know that it's below the cost-based rate until we know what the cost-based rate is? I thought that's the problem, is that there needed to be more information to figure out what the cost-based rate is. So we don't know which one's the lower one.
Well, I guess you do. I mean, again, the FCC, you're right, has not said what the right rate is for purposes of refunds. But obviously, the benchmark that they calculated is 0.56. And then in the second rate order, the rate proposed was about 0.3 cents, just below. And so you know that the cost of service in this period at least is the one that's really driving the unreasonable determination.
But I thought I thought in that period that cost-based rate hasn't been validated either, because that's also one as to which more information needed to be supplied.
No, I think like I said, I think in both cases, there will have to be a determination of what refunds are owed. But what I guess I thought you were saying is, how do we know that the cost of service is the governing rate? And it's because what was rejected was a 0.3 tenths of a cent rate. And so, by definition, in these two periods, the rate's going to be below 0.3 cents, right? And so we know that the cost of service, again, that's what we're saying. If you rule in their favor and say, hey, this benchmark doesn't apply, which obviously we disagree with on the merits, but if you rule in their favor on that, those two tariff rates are going to remain rejected because...
Well, I'm sorry to interrupt you, but isn't it the case that, at least conceivably, that Aureon could support, that the additional data that the FCC wants could either validate the rejected rate or indeed they'd find something that pushes it higher? I don't know. We don't know until we know.
Well, I guess that goes to what I understand the proceeding, which is, again, if you look at paragraph 127 of the first rate order, it says, this investigation as to this tariff is terminated, and the rates under investigation in this proceeding are unlawful and subject to potential refunds or over-earning. So I think,
right,
I would certainly,
yeah.
Right, and so that's what I'm saying. Yes, the FCC, I think the way it may work, either the FCC will say, here's what we think the rate was based on the evidence, or Aureon will say, here's a refund plan, and people will comment on it and say it's either right or wrong. But I don't think it's open. Certainly AT&T would say, hey, it's too late for this period for Aureon to come in and put in new evidence to support the cost of service rate. That's over. You're done. You didn't do that. The rate is unlawful, and that's frankly why the filed tariff rate has nothing to do with this case. The filed rate was declared unlawful. And in this period, an unlawful rate can't be enforced. And that's been the law for centuries. All right. Thank you, Your Honor.
So it cannot cure the lack of evidentiary support. I thought it was sent back for that. I'm sorry. It can't cure the lack of evidentiary support, is what you're saying.
That would certainly be AT&T's position. That again, the proceedings. In some ways, if the proceeding's not over and we're still trying to figure out what the rate is, I don't even know that this is really you would have jurisdiction, because obviously you only have jurisdiction over final orders of the FCC under 402A or B. But I think it's final because of the reasons that I just said, and that's why you have jurisdiction to review today. I hope if that makes sense. Because I don't think it really is open to them to come back in and say, hey, our rate is reasonable. Potentially they could come back in their refund plan and say, hey, this is the amount of refund that we're offering, and and here's why that rate is reasonable for purposes of contrasting what was paid versus what the reasonable rate should have been. But that's a much different inquiry than saying, hey, we get to come back in and potentially show that our proposed tariff rate of 0.57 or 0.29 is reasonable. I think that's foreclosed.
So how do I understand in paragraph 122 at page J591, we require Aureon to file a revised tariff along with revised cost support. And then they did. Right. This is the first, they did that. Yeah, they did that.
No, right. So I think that this was the first rate
order. That was the first tariff order. So they did that.
It covered from the time of the initial tariff filing, which I think was in February of 2018, and then this order is issued 5 months later under the statutory clock. And then they're ordered, because the tariff rate wasn't sufficient, they're ordered to file a new tariff. And then at some later date, I don't have that exact handy, they file a second tariff and they further reduce the proposed rate to 0.3. Right. And then there was a second proceeding, we did it all over again, and we said, hey, you still haven't justified your costs. That's all. The second proceeding only concerned the cost of service, because they had already set the benchmark and the rate was, the proposed rate was below the benchmark that the FCC had calculated.
Yep, got it.
And then that tariff, and that proceeding is also subject to refunds. If there's no further questions, then I'll turn it over to Mr. Chair. Thank you.
Thank you, Mr. Hunsetter. Mr. Scher.
Good morning, Your Honors. May it please the Court. William Scher on behalf of respondents. None of Aurion's claims is properly before the court. Aurion's as-applied challenge to the benchmark rule is premature because the rule has had no concrete impact on Aureon yet. The FCC calculated the benchmark in the underlying tariff investigations, but the FCC didn't prescribe the benchmark as the lawful rate going forward. Instead, it twice directed Aureon to justify its cost-based rate. Aurion's claims of harm from the benchmark rule remain hypothetical. And rather than too early, Aurion's statutory arguments are too late because it failed to present them to the agency first. Aureon argued that it can't be subject to the benchmark rule in a prior FCC proceeding, and it ultimately lost that argument in this court. Now it's back with various statutory arguments, the crux of which are the same, that Aureon can't be subject to the benchmark rule.
Mr. Scher, can I just stop you there? So are you disagreeing with Mr. Hunseter about the clarity? He's saying that we now know that the cost-based rate is unlawful, the benchmark rate is going to be what applies. And it sounds like you're saying it's not clear. It hasn't been prescribed.
In both of the orders on review, Your Honor, the FCC, the FCC calculated the benchmark rate in the first rate order. In both the orders on review, the FCC terminated the investigation without prescribing a rate or identifying a lawful rate. Instead, what it did was send Aureon, direct Aureon to revise its tariff and to provide more support for its cost-based rate. Now, after the orders on review, so after these tariff proceedings that are here before you, ultimately, Aureon filed a rate that the FCC allowed to go into effect. It's a cost-based rate, and I think it's identified in Aurion's brief around page 9.
So then can you help me understand the context? Because the third rate, the one that's been allowed to go into effect, is not before us. That kicked in sometime in 2019 and has been in effect since. So what's before us is the rate that should have been in effect for the period from 2018 to 2019. And as to that, it sounds like you're saying there was never a definitive determination of what the rate should have been, because both times it came up, the FCC sent it back both times and said, you need to present more information to justify the cost-based rate.
That's all correct, Your Honor. And
then if that's true, then I'm still not understanding how we get past the starting gate, because if we don't know what the cost-based rate is, because there needed to be more information, then we don't know which is lower, the benchmark rate or the cost-based rate. And if we don't know which is lower, then we don't know which is the governing rate. So a challenge to either of them seems speculative.
That's correct, Your Honor. And so we've made a ripeness argument, and I think that ripeness is a time-bound approach to standing, but our basic point is that there's been no concrete impact.
Then why doesn't your ripeness argument, if we just assume that it's ripeness/standing, meaning that things haven't germinated to a point that we know yet which rate is in effect, so a challenge to a rate that may not be in effect is unripe, as I understand it, the gist of your argument. If that's true as to Aureon's petition, why isn't it also true as to AT&T's? Because AT&T is also challenging some rates, and it seems like the same logic. We heard Mr. Hunseter say that same logic doesn't apply. I just want to know your perspective on why doesn't the same logic apply, because either of the rates that they're challenging, they have a challenge to the benchmark rate and they have a challenge to the cost-based rate, but the same logic would say, well, we don't know which rate is in effect for the relevant period, and so neither of those challenges are ripe.
Well, I think in our brief, we conceded the point that if AT&T were to prevail on either of its challenges, one of which is to the benchmark rate calculation, one of which is to the cost-based rate calculation, that the rate that was ultimately prescribed after these proceedings would be lower. Now, it's possible that the FCC ultimately, assuming that this case doesn't settle before that, will have to issue a refund order for the periods that are subject to these two tariff investigations, and it'll have to decide on refund amount, and presumably they'll have to identify what the appropriate rate should have been to determine that refund. It's possible that that if AT&T were to prevail and were to lower either of those rate calculations, that it would have a greater refund.
And that's because of the impact on the rate that kicked in 2019 and is now in effect, or that's because of something that happened from the 2018 to 2019 period?
I think I can't speak definitively because the FCC hasn't engaged in the analysis of how to determine the refund. But I don't think that the lawful rate, which is currently in effect and which was approved after the subject orders, would necessarily dictate what refunds were owed. I think that over the course of the underlying proceedings, Aureon submitted different proposed cost-based rates. I think that the rates fluctuated in part because there were different demand projections because it happened over a period of time and there were changes. So I think again, if and when the FCC has to engage in a refund analysis, it may bring up some different complicated issues.
So then let me just ask one last question on, I think at least at this time. If the reason from the Commission's perspective, AT&T's questions get answered is that it has to do with potential implications for the refund, which as you're describing it now is for the 2018 to 2019 period, then why doesn't that same reason also apply to Aureon? Aren't they also affected by the amount of the refund?
Well, I would say two things, Your Honor. I mean, first of all, Aureon's challenge is solely to the benchmark rate and to the fact that it's subject to the benchmark rate. So it's not challenging, the calculation of that rate. I guess the other thing I would say is that if and when the FCC issues a refund order, and if that refund order orders refunds based on the FCC's calculation of a benchmark rate, which presumably would only happen if AT&T were to prevail, then I believe that Aureon ought to be able to challenge that refund order. At that point, there would at least be some concrete impact on it of a benchmark rate, which didn't happen in the orders on review.
But you don't say the same thing about AT&T, that AT&T could also challenge a refund order and get?
I would say the same thing about AT&T.
But then why?
Well, I mean, Your Honor, we didn't challenge either party's standing, and in our brief, what we said about AT&T's claims was that they would affect the calculation of either rate, and that they would bring the rate lower than the rate that is presently in effect. But as I said before, that rate is not before you.
Right. So that I'm not understanding that aspect of it, because if that rate's not before us, that seems like that could be a separate proceeding that somebody would bring at some point, assuming that there's, you can get past any threshold issues there. But we're only talking about the 2018 to 2019 period. So that basis kind of drops out, I think, right? Because that has to do with something that happened later.
Yes.
And we measure standing by reference to the state of affairs at the time that the petitions were filed.
Yes, that's correct, Your Honor.
And I mean, right, bracketing, except that it's interesting that despite predictions that the cost-based rate would always be higher, the cost-based rate came in as lower than the benchmark. But that just seems like an interesting fact, but not directly relevant. What I had understood to be the reason that AT&T believes it has standing even as it assails Aurion's standing was that it is challenging both calculuses. And so there isn't a situation in which its case would be irrelevant, which is true with Aureon. That Aureon is not challenging the cost-based rate, and therefore if the cost-based rate were lower, that would be the one that prevails. So it's all the challenges that it raises to the application of the benchmark rate would be advisory on our part. But what I'm not clear about is what I had not previously observed was Mr. Hunstetter saying that that he doesn't think there is any further cost information that's going to bear on the nature of this refund. And I thought I heard you say the opposite.
I don't think, I agreed with Mr. Hunstetter's characterization of what would happen in terms of, I don't think that there's not going to be any further proceedings before the commission regarding the period at issue in the investigations before you, whereby the commission will have the parties come in to try to establish what the lawful rate should have been during that time.
Cost-based rate.
The cost-based rate, but the commission will have to determine some basis on which to order any refunds that may be owed.
Meaning it will have to determine what the two rates are, or if there's, I thought Mr. Hunstetter was saying the whole notion of a cost-based rate is off the table because Aureon never came up with the data that would be required to support a lawful cost-based rate. Therefore, we default to the benchmark rate?
I don't think that's necessarily the case, Your Honor, because ultimately Aureon made the showing that the commission directed it to make in the two orders, and ultimately a cost-based rate went into effect. So it's not impossible or out of the realm of possibility that the commission could determine that the appropriate cost-based rate for the 2018-2019 period was the basis on which to order any refunds.
And in that case, Aureon wouldn't have, and in that case, Orion's challenge wouldn't apply to that because they haven't challenged the cost-based rate.
Correct, Your Honor.
Because they've only challenged the benchmark rate. So if but that makes it sound like we don't know yet whether for 2018 to 2019, the governing rate for purposes of calculating refunds is the benchmark rate or the cost-based rate. It could still be either one.
Yes, I believe that's true. Yeah.
If that's true, then, and if that's the reason that Aureon's claim is either ripe or doesn't have standing, I think they sort of seem to boil down to the same thing here, the way you're looking at it, then it's still not apparent to me why that's not equally true with AT&T. I guess one way to ask the question is this. Suppose from the commission's perspective, just suppose that the only challenge AT&T was making was to the benchmark rate, and they don't have the challenge to the cost-based rate. It's just not in the case. I know that it is, but let's just assume that it's not. Then would you be making the same argument for AT&T as you would be for Aureon?
I mean, I think that that implicates Judge Pillard's idea that it was because AT&T was challenging both. I'm not certain that's the case. I mean, our approach to it, I mean, from my perspective in looking at these cases when we began briefing and going through the threshold issues, I had difficulty with this. Section 204 has a specific provision that these tariff investigation orders are final and appealable, regardless of the outcome. So there was no issue as to finality. And the fact that AT&T was arguing for a lower benchmark rate that might ultimately make a difference to it seemed important to us. So I don't know that if AT&T was only challenging the one, that would have made any difference in terms of our analysis, which may have been insufficient as this whole colloquy is pointing out.
Can you explain to me the difference? Because I take it you continue to think that the Aureon challenge to the benchmark rate is unripe.
Correct.
Then why do you think that the AT&T challenge to the benchmark rate is ripe?
I'm not gonna. I don't want to sit here and advocate for its ripeness. If I could make, if it was possible, it's possible for me to make a distinction only based upon the existence currently of a cost-based rate that's in effect. Now that that rate, as you recognized before, isn't before the court presently. But that's the distinction, the factual distinction, the contextual distinction that we had in mind, and that would make a difference, I guess, if it did make a difference, if it were relevant.
You're talking about the cost-based rate for 2019.
I'm talking about the cost-based rate for the period after these tariff investigations, which is presently in effect and doesn't bear on this case.
And I guess what I'm still missing, and it's very possible that I'm not understanding the context correctly, but I'll just ask you to help me, is the basis that you've just thrown out that you've just offered for a potential distinction between Aureon's position and AT&T's position vis-a-vis a challenge to the benchmark rate is that, well, if you take into account the fact that there's a cost-based rate in effect for 2019 forward, then that might have implications that would somehow make AT&T's challenge to the benchmark rate ripe. And I guess what I don't understand then why would that not equally be true of Aureon's challenge to the benchmark rate too? What I'm not understanding is why they don't stand or fall together, no matter what consideration we take into account.
I guess the distinction I would make with respect to Aureon is that what Aureon is challenging is we shouldn't be subject to the benchmark rate. There were 2 tariff investigations. Neither of them prescribed the benchmark rate. Ultimately, after this case, a cost-based rate went into effect and is now in effect. So we don't know, it's contingent on future events, whether Aureon will ever be subject to the benchmark rate. Since Aureon isn't challenging the cost-based rate, there's no impact even on what happens after this case. But I think
isn't that also true of AT&T's challenge to the benchmark rate, though? It seems like everything you just said would be, but I may be missing something. But it seems like everything you just said would be equally true of AT&T's challenge to the benchmark rate.
Yeah, I think I'm not going to continue to advocate a distinction. I think I'm going to concede that sitting up here I can't identify a distinction. I would just point out that with respect to Aureon and the threshold objections, we've made a ripeness argument with respect to Aureon's as applied challenge, but with respect to their various statutory arguments, we've also made 4 or 5 objections, which are separate bars. I see that I'm out of time.
Can I just ask you, I just want to ask you one last question, which is on a different topic, if I could. So it doesn't sound like you have an awareness, the commission has any awareness of the negotiations as to which we received the document yesterday. And so I'll just assume that, but you of course are free to tell me otherwise or free not to. But my question is this: if both petitioners decide to dismiss their petitions because they reach some sort of accord that in their view enables them to withdraw the petitions, are you aware of any reason that the commission would then stand in the way of the case going away? Either would have the authority to do that or would want to?
No, absolutely not.
Okay, unless my colleagues have additional questions for you, Mr. Chair, we'll give them the rebuttal time. Thank you.
Thank you, Your Honor. Mr.
Troop, we'll give you 1 minute of rebuttal.
Thank you, Your Honor. Two things I want to correct. First of all, all this talk about rejection. Rejection only occurs before a tariff goes into effect. There was no rejection in this case. There's questions about what cost-based rate was in effect in 2018, 2019. The cost-based rates that were in effect were the tariff rates that were filed. The FCC's orders say those rates remain effective until the compliance tariff filing. So those cost-based rates in 2018 and 2019 were effective. As far as standing and ripeness, this case will not get any more right. Aureon will never file a cost-based rate above a benchmark as long as that's going to incur penalties and prosecution. But it has a right under Section 205 to file a rate that allows it to earn the minimum rate of return prescribed by the FCC that it is required to stay in service. With respect to the refund benchmarking, Part 65 of the FCC's rules provides earnings review retroactive rate making is improper. They can't go back and change the rate with respect to benchmark. 205 only allows them to do that prospectively. We can't go back in 2018 and increase our rates. They can't go back in 2018 and reduce the rates which were effective. That's unlawful retroactive rate making. Thank you, Your Honor.
But they can order a refund.
Under Part 65 of the FCC's rules, there's a procedure for refunds. We look at the rate of return, and new data that's a whole new proceeding, and that involves even different years from 2018, 2019. The rules specify the 2-year monitoring period for their earnings. That's not 2018, 2019. No new data is going to be involved in the 2019, 2018 rates. The orders say that those investigations were terminated. And any changes to those rates by saying, okay, now we're going to do a refund based on a benchmark retroactively, that's retroactive rate making. That's improper. The FCC can only prescribe a new benchmark or new rate prospectively under Section 205.
Okay, unless my colleagues have additional questions for you, we'll hear from Mr. Hunstetter for his 1 minute of rebuttal.
I'd like to turn back to the standing point. I think our position is consistent with what Judge Miller articulated, that we think the combination of the two challenges to the cost of service and to the benchmark mean that there is standing for us, because again, we'll know that potentially, well, if we prevail, then that does affect the range of refunds that are available to us. So I think that's our position on standing and why we have standing. On the other hand, like I said, if Aureon prevails, and you assume that they prevail, those tariffs are, and it sounds like we're in agreement, they're going to remain rejected and they're never going to come back into effect. And so there's never any redressability as a result of this court's actions that it would take on Aureon's position. So
but if it prevails, it's challenging the benchmarks. If it prevails, it affects the size of the gap between what it billed and what it's entitled to.
It would affect the size of the gap, but again, we know that, again, right now, it's at 0.5634. And again, we know, because they rejected a rate that was far lower than that benchmark of 0.3, or a little bit below 0.3. You know, the rate that, whatever rate is set for the refunds, I think it's fair to say it's going to be below 0.29, because they already rejected a 0.29 rate, and I don't think they can go back and revisit that and say, hey, we actually think the rate is 0.4 or 0.6. So I do think it's going to be lower than 0.29, the last proposed tariff rate that was issued in the second rate order. And so that's why I think, like I said, there's really no redressability. I mean, yes, the gap would close, but again, that gap has no real impact, or would never have any real impact, I think, if that's how I understand.
The gap had a major impact on the size of it. It's the same thing you care about. It has an impact on the size of the potential refund.
It does for us in terms of the refund, but I think for them, like I said, we know their rate. I mean, they've conceded, and I have to get feedback, I apologize, but they've conceded that the 0.3 rate, I mean, there's been a finding that the 0.3 rate is unlawful. And so no matter what happens to Aureon's claims, in this period, they'll never get a rate above 0.3. And so that's why I'm saying I think there's no redressability. Even if the gap narrows, there's really no redressability, because it doesn't affect the tariff's lawfulness or the refund.
It doesn't affect the cost-based tariff's lawfulness, but since they're challenging, I guess what you're saying is they're not challenging the level of the benchmark, they're challenging its applicability at all.
That's correct.
And that way, if they were challenging the level of it, they would have standing for the same reason you do. But because they're challenging its existence without and you're saying we kind of know the neighborhood that it's in, and we know that Lost it. Sorry.
Okay. No, I do think that that's correct. We sort of know the neighborhood that it's in. And that, like I said, no matter what, if you rule that they're subject to the benchmark or they're not subject to the benchmark, nothing is going to change in either of the two tariff review proceedings. And I think that's kind of the end of the matter for Arya. Thank you.
Okay. Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 20-5223 et al. American Federation of Labor and Congress of Industrial Organizations versus National Labor Relations Board Appellant. Mr. Thomas for the appellant, jurisdictional issues. Mr. Weiss for the appellant, merits issues. Mr. Ginsburg for the appellee.
Morning, counsel. Mr. Thomas, please proceed when you're ready.
Good morning, Your Honor. May it please the court, Paul Thomas for the National Labor Relations Board. This case presents a jurisdictional question of critical importance for the NLRB and the parties who appear before it. Namely, is this court's jurisdiction over challenges to rulemakings original or appellate? Under this court's decisions in Investment Company Institute and New York Republican State Committee, the answer is original. The NLRA's Judicial Review Statute, Section 10F, is ambiguous as to whether it covers rulemakings, and under those cases, ambiguities should be construed to avoid a bifurcated review process whereby some types of review go to the Court of Appeals and others to the district courts. Accordingly, we ask this court to convert this case to an original petition for review.
Can you tell me why the board has changed its position on this jurisdictional issue? And I think the board doesn't contest that rulemakings, challenges to rulemakings have always previously been brought in district court. So why what's caused the board to rethink this jurisdictional question?
So first, the premise of your question is correct, Your Honor. The board has certainly the prior challenges to rulemakings have proceeded in district court. I think the basis for the NLRB's change of views on this issue is largely down to the court's decision in New York's Republican State Committee and its reemphasis on the preferred avoidance of bifurcated judicial review proceedings. That case, I believe, issued after the most recent litigated NLRB. There have only been a few litigated NLRB rulemakings in the past, and it issued, I believe, after the most recent one of those.
But even in that case, it says absent a firm indication that Congress so intended, right? So it's still, so there might be a presumption, but the presumption only applies based on the text of the statute.
That's correct, Your Honor. The presumption, it can be rebutted by a firm indication on the part of Congress that it intended for a bifurcated review structure to hold. And there are a number of this court's cases that find such a firm intent in the context of, for instance, statutes that specifically isolate rulemakings under certain provisions of the statutes and then implicitly exclude rulemakings under other parts of the statutes. But that's not the statute that we have here. The statute that we have here, by its terms, applies to final orders of the board, but it does not say, for instance, final unfair labor practice orders of the board. So in our view, the text of Section 10F of the Act does permit a finding that it applies to rulemakings. It doesn't necessarily command a finding that it applies to rulemakings. We're not going that far, but it does permit a finding that it applies to rulemakings. And the Act's context provides no firm indication of a congressional intent to bifurcate review. The reason why, when we know the reason why Section 10F was placed within Section 10 of the Act, and the reason why is the reason that the Supreme Court articulated in the original AFL case in 1940, which is that judicial review is placed in Section 10 of the Act in order to ensure that it could not be employed to review certificates of election results, which the Congress found, and it's discussed extensively in the Act's legislative history. The Congress found that courts were delaying certifications of unions under the precursors to Section 9 of the Act, and Congress wanted to avoid judicial review of those types of certifications. It was not considering judicial review of rulemaking when it structured judicial review provisions. And as this court articulated in New York Republican State Committee, there are a lot of statutes from that era of history, of congressional history, that don't directly address the issue of where rulemaking jurisdiction is to be located because Congress wasn't considering the issue. And finally,
question not just. Oh, go ahead.
No, please.
Isn't the question not just rulemaking versus orders, but this provision on that you rely on direct review here in this court is in the whole part of the act that deals with unfair labor practices, and it references unfair labor practices in a manner that really makes it appear that the direct review to us was limited to unfair labor practice cases.
So it's certainly true. So there's two issues there, Your Honor, that I would like to unpack. So the first is the issue of where it's located in the statute, and that I think is addressed by the point that I was making regarding the desire of Congress basically to exclude judicial review of Section 9 certification proceedings. The second is the Act venue clause, and that I will admit is the best argument that AFL-CIO has, is that the Act's venue provision does say, the unfair labor practice in question. However, the Act has a highly flexible venue provision that provides for venue in a variety of different circuits, and in particular, it provides for review anywhere that the respondent resides or transacts business. It's actually very difficult. It's not impossible, but it's very difficult to come up with a unfair labor practice case that actually implicates the unfair labor practice in question venue provision. And in our view, allowing the mouse hole of a venue provision relating to a particular very narrow factual circumstance to contain the elephant of requiring that judicial review of rulemakings be conducted in district courts is a bridge too far. I mean,
even if it doesn't practically, I take it that what you're saying now is it may not practically be implicated very often, but even if that's true, the language, as you sort of acknowledge, it doesn't even say wherein any unfair labor practice occurred. It's the unfair labor practice in question occurred, which makes it sound like that's the universe of things that are being contemplated is unfair labor practices. And then you look to see where the particular one in question occurred, and that gives you a venue toehold. Even if it's a practical matter, that particular prong of this may not come into play in every case, but it appears to contemplate that that's the universe of orders that are being considered.
So what I would say in response to that, Your Honor, is that the definite article in that section of the statute has never been interpreted literally. Certainly, for instance, there are a number of cases where you might have multiple unfair labor practices occurring in multiple different venues. So I don't think that the choice of the definite article there has ever really been found to be of significance. But the key point that I want to reemphasize here, in regards to the issue of in regards to the venue issue, is that we don't think that the venue provision is like, we agree that it's evidence in support of AFL-CIO's position. What we don't agree with AFL-CIO on is that it's sufficient evidence to be dispositive and to overcome the presumption, the powerful presumption in favor of not bifurcating judicial review. So we agree that it points in the direction that they're saying it points in. We just don't think the magnitude is sufficient to carry the day here. And if I just one final point, Your Honors, and I see my time has expired, which is that when you look at the overall structure of the Act, it displays a clear preference by Congress to avoid policy making by district courts on Labor Act issues. District courts are given very ancillary minor roles under the Act that don't involve adjudication of questions on the merits of what is and is not permitted under the National Labor Relations Act. It would be an extremely anomalous result to find that those courts had jurisdiction over rulemakings, which would permit them to exercise a kind of jurisdiction that we don't think the 1935 Congress could ever have intended.
Well, wasn't the APA, and the APA was enacted after the NLRA, right? Which ordinarily places review of rulemaking in district courts.
That's correct, Your Honor. But I'm not sure whether that, I mean, one could argue that that actually plays in the favor of a finding that circuit court review should be permitted here, because at the time of the Act's passage, it wouldn't have been clear that judicial review in district courts was even necessarily available. Now, I know there was non-statutory review. I mean, that was before the merger of law and equity. I mean, it was a very different legal time period. But if anything, I think that might actually weigh in our favor.
Okay, unless my colleagues have further questions for you at this time, we'll hear from Mr. Weiss on the merits questions. Thank you, Mr. Thomas.
Thank you, Your Honors.
Thank you, Your Honors. Tyler Weiss on behalf of the National Labor Relations Board. May it please the court. With regard to the merits of this case, this matter concerns the procedures utilized by the NLRB in processing representation cases under Section 9 of the National Labor Relations Act. Consistent with the Act and the guidance provided by the Supreme Court in cases such as Inland Empire v. Millis, the Board has long established regulations governing the procedures to be utilized in representation matters. As recognized by the Supreme Court in A.J. Tower shortly after the NLRA passed, these representation procedures necessarily involve the balancing of competing interests, such as accuracy in election results, efficiency in reaching final resolutions, and the speed in which these results can be reached. Here, the Board reasonably exercised its judgment, as it has on many other occasions in the past, to modify its election procedures to better serve these competing interests. AFL-CIO's challenges to these rules ignore two key principles of administrative law. First, that these rules govern election procedures and change no substantive standards for what is required to obtain a certification from the Board. And second, that it is the Board and not AFL-CIO that is tasked with balancing the competing interests that inexorably occur in conducting Board elections. Unless the court would like to proceed otherwise, I'd like to start with the notice and comment issue and the procedural nature of the Board's rulemaking. So with respect to that issue, I think there's the best way to frame the Board's rules is to look at them comprehensively and to ask three questions. First, what do the rules do? What the rules do, in effect, is they modify the procedures for Board elections. They reorder steps leading to certification, they change timeframes, and they adjust who is allowed to present positions to the agency. What they do not do is change any of the substantive standards required for obtaining the Board certification. The second question is, why did the Board pass these rules? And as the Board exhaustively explained in its Federal Register entry.
Mr. Weiss, can you back up for a minute and just, I don't know if you're able to shed any light on why the Board decided in 2011 and again in 2014 to use notice and comment rulemaking and amending its representation procedures. And I know that at least in 2014, it assiduously said it didn't think it was required to do so, but do you have any understanding of why that was done?
Your Honor, to be honest, I don't have an answer to that direct question as to why the Board sought notice and comment rulemaking, other than to, again, highlight the point that you raised, that even in 2014, the Board did not feel that notice and comment was necessary. And then prior to both 2011 and 2014, the Board had modified its representation case procedures on dozens of occasions and had never utilized notice and comment rulemaking in any of those cases. In prior matters. But beyond that, I can't speak to the 2014 Board's motive in engaging in notice and comment rulemaking. But turning back to the agency's justification for why it passed these rules are justified by concerns of agency efficiency, uniformity, certainty of guidance to parties, and finality. They're part of a broader effort to organize and evaluate questions concerning representation in ways that are most efficient and most logical before the agency. If you look at the dozens of pages that the Board drafted in the Federal Register, at no point is there any suggestion that these rules are passed to change outcomes in cases, change the substantive rights, or the interests of the parties. And then the third question in looking at these rules is, what are the effects? And in terms of the substance of the rules, the effects are nothing. As the Board itself pointed out in footnote 17,
Prior rule changes dealing with timelines and similar issues addressed in these rules had no effect on union win rates. The rules here apply equally to certification elections and decertification elections and apply equally to all parties. To the extent that these...
Can I ask you a specific question about the certification timing change? There's the AFL-CIO talks about the right of recognitional picketing, right, which might be affected by the timing of the certification. Can you speak more to why that is not a substantive change?
Certainly, Your Honor. And as we addressed in our briefing, we cited to it's been longstanding board precedent that the pendency of a representation case petition actually privileges recognitional picketing. I believe the case is International Hod Carriers, and it was addressed in our briefing, I believe.
And by privileges, you mean that such picketing can go on even while the certification is delayed?
Correct.
The certification is delayed. So there's no substantive impact on the picketing?
That's absolutely correct, Your Honor.
Mr. Reese, you refer to these as certification case procedures. I think in the brief it actually referred to them as election procedures, and it seems like there's a lot of, daylight or different spin on them depending on how you think of it. I mean, that the challengers here refer to, time for campaigning among potential members of a unit. They refer to, the period of time under which they function, represented by their chosen union. And those are all things that are really at the heart of what the Act protects. So you can say it just has to do with timing, but they're talking about the timing of the very ultimate entitlements that the Act is about. Why isn't that a reason, when we're obligated to construe exceptions to notice and comment rulemaking narrowly, why isn't that a reason to say, well, this isn't really limited to agency procedure?
Well, Your Honor, a couple of points in response to that. First, I believe with regard to the time for campaigning issue, which I think generally attaches to the extension of time between the decision and direction of election and the election itself. That extension of time applies equally to all parties. It gives the union additional time to campaign, and it gives the employer additional time to campaign. Now, that's not the justification for the board's rule. The justification is that the board wanted to have more time internally to rule on requests for review before elections occurred. With regard to the second point, which I think attaches more to
the other thing, they talk about getting the member list, and they do make this point that, back in the 60s, 5 days was enough. Even when we're dealing with paper records and U.S. Postal Service, surely 5 days is excessive when we're talking about a important period for contacting members.
Yes, Your Honor, but a couple of points again in response to that. First is that given the corresponding extension in time between the petition being filed and the issuance of the decision and direction of election and the election, that the union actually has as much time or more time with that list between when they receive it and the election than they did under the prior rules.
But it has a week less than, or it has several days less than the employer.
Well, the employer has that information by default, presumably.
Exactly. So the employer has the information ahead of the union, is what I'm saying.
Yes, but that's the case regardless of the timeline of when the list is being provided. And I think it's important to look at the board's explanation for why the time period for the list was extended. And that justification rests almost entirely on not having to rerun elections, which is an internal agency concern. What happens when there's inaccuracies in a voting list is that oftentimes the issue will be litigated, and then if those inaccuracies or issues in the list are substantiated, then the agency has to go back do everything all over again, which obviously implicates substantial efficiency interests for the agency.
And does the record identify any cases of that happening during the period under the shorter time?
I apologize, Your Honor. Not specifically, but the record does identify several cases in which the board noted where employers had difficulty complying with the list given the short period of time, including, I believe it was a 5,000 person bargaining unit with Harvard, and then several other multi-location units that are explained in the Federal Register. And if I may, I'd like to.
Why does the rules on that? It says absent extraordinary circumstances. So is that an extraordinary circumstances caveat that was actually practically in use?
I can't speak to the exact circumstances of the Harvard case in particular, whether that explicit exception was implicated in that list. My understanding is, and I may be mistaken, but I believe that the employer was able to comply with the list requirement in that case, as the board indicated in its rulemaking. And I'd like to I see that I'm out of time. So if the court would like me to address any of the other remaining issues in the case, I'd be happy to, or I can continue.
I'd like to hear about the statutory argument about the impounded ballots, because as I read it, the rationale in the briefing and the rationale in the rule are quite different.
Yes, Your Honor, there is I'll admit, some daylight between what the board stated in the rule and what we have argued in briefing. But that being said, our arguments as to the meaning of Section 3B are plain language arguments. They're arguments about what the statute of the text actually says. It's not a Chevron Step 2 argument about deference being owed to the agency based off of its interpretation of the rule. What we're arguing is that the literal text of the statute, at least as our primary argument, that the literal text of the statute does not apply to what the board did here, that there is in fact no stay of an action taken by a regional director. And I think it's that word taken that carries all the weight in this case. Because if the statute said that, if the statute prohibited stays of any action by the regional director, then you would have likely an issue, because the impoundment provision is affecting actions that are happening in the future. But when you add the word taken into the statute, the only natural meaning of that term is to apply it to actions that have already occurred.
That's not the way that taken is used in that statute. That's a grammatical error. I mean, it's a past participle being used here to form the passive voice, because it's like the actions that the regional director takes or actions taken by the regional director, just flipping the order of the sentence. And indeed, when you're talking about something like stay, typically it's action that's either presently ongoing or upcoming, because otherwise, if it's fait accompli, it's not really stay-worthy at all. So it seems, actually, if we're looking at clear language, it seems like, and we had to choose a clear reading, it seems like a clearer reading is that taken is being used there in an adjectival form to allow the drafters to use a passive voice. And we've recognized that. I think the Supreme Court recognized that in Henson versus Santander Consumer, which I don't think a party cited, but it's 137 Supreme Court 1718 at 1722. It's a 2017 case, explaining that it's technically a present tense when used that way.
Well, thank you for that citation, Your Honor. And just a couple brief points in response to that. The first is, in the event that the plain language doesn't answer the question presented by this issue, the board did explain briefly in its rule why the impoundment provision is not in fact a stay, and that is because and this is actually at the deferred appendix page 210. There isn't a stay in this case because the election is going forward, and that the regional director is continuing to act. They're just I believe the word the word the board uses is that it's simply postponing the count. Is the board?
But it's the postponing of the count that is being. I mean, it's the count that's being stayed, and so that distinction on its face is actually to actually make no sense at all. This is not a stay; it's just a postponement.
That, in essence, that is what the board has said in its rulemaking.
That's what I read it to be saying, and I didn't find that to be supportive of the rule.
With respect to the board, though, the board has the authority to conduct elections itself, right? Or it can delegate that authority to regional directors.
That's correct, Your Honor.
And so can they also, I mean, presumably since that authority to the regional director is only a delegated authority, the board can also condition how it delegates its authority to regional directors in the conduct of elections?
That's absolutely correct, Your Honor, as was addressed by the Supreme Court in a case called magnesium casting that we cited in our brief that extensively discusses the 3B delegation by the board to regional directors. And just a practical point in response to Judge Collard's questions. Impoundment is something that occurs in board elections regardless. It was a historical practice of the board for decades before the 2014 rules were enacted. In fact, under those rules, anytime a request for review was filed, all ballots were impounded. Even under the 2014 rules, as the board discusses, ballots were being impounded at the end of elections to preserve important interests such as voter secrecy and ensuring that there wasn't a spoilage of the overall election based off of, for example, challenged voters. And so,
when that happened, was that because the board was ordering that they be impounded?
No, Your Honor. That was a product of the general counsel determining that impoundment was necessary. So the agency is bifurcated between the board and then the general counsel's office, and that was actually a general counsel policy memo that directed the impoundment procedures under the 2014 rule. But
not exercising board authority. So it's not an application of the statutory provision that says unless specifically ordered by the board.
Well, I think that would depend on how the phrase "the board" is interpreted within the context of that statute. Sometimes the board is interpreted to mean the 5-member decision-making body. Sometimes the board is interpreted to mean other terms.
But
how does the board? I mean, the general counsel is not the board, presumably.
That's correct, Your Honor.
So it's not it's not an application of that provision, but because as you understand that provision, it doesn't. The general counsel is distinct from that. This was just the general understanding that was in effect, was that impoundment was just something that was available, and it was being done.
I believe that to be the case, Your Honor, if I'm understanding your question correctly. But I think the larger point that I wanted to make was simply a practical one, that impoundment is a necessary artifact of running representation elections in board proceedings.
Did anyone challenge after 2014 the use of impoundment under the 2014 rule as being inconsistent with the statute?
Not that I'm aware of, Your Honor, and in fact, under the board's historical practice, although I haven't done full research on it, I'm not aware of anybody making this particular argument in prior cases, either when there was an even broader impoundment provision that was in effect for decades. Those cases may exist, but I'm not aware of them.
Thank you.
Make sure my colleagues don't have additional questions for you, Mr. Lees. Thank you. Thank you, Mr. Weiss. We'll hear from Mr. Ginsburg.
Thank you, and may it please the Court, Matthew Ginsburg on behalf of the American Federation of Labor and Congress of Industrial Organizations. I'm, of course, happy to take any questions on jurisdiction. However, we briefed the issue fully, and if there are no questions, I'd like to move directly to the merits, as this Court, whatever it decides on jurisdiction, will have to address the merits. If that's it. if that's okay. Okay, great. So to begin, the district court was correct in its determination that notice and comment was required for the 5 provisions that we've challenged in this litigation. The challenged provisions all directly address how regulated parties engage in the primary conduct that's authorized by the National Labor Relations Act, how the parties seek employee support for or against certification of the union as the collective bargaining representative in board-conducted elections. So in changing the rules in a manner that makes it more difficult for the union to win the election, to win employee support, and thus to obtain certification, each provision encodes a substantive value judgment and alters the right and interest of the parties. And you can see this both from the very terms of what the board did in the rules themselves, as we've described in the briefing, as well as how the board has explained what it was doing. And I want to I may be limited in time in addressing each single rule, but I wanted to start with the rule concerning the determination of individual eligibility as a prerequisite to obtaining an election. So the board's rule says that normally every individual eligibility must be determined under the new rule, and that is not required by the National Labor Relations Act. Frequently, the status of individuals as supervisors or as in or out of the unit are non-determinative of the outcome of the election. And in those cases, which occur regularly, the parties typically resolve such issues in collective bargaining subsequently, if the union, in fact, wins the election. And of course, if the union doesn't win the election, then the issues are never resolved because they're not determinative. The board, so in and of itself, the board has interposed an additional.
Wait a minute, they're never resolved. So you end up having the employer and the union effectively by agreement, including people in a unit that the law does not support, should be included.
Well, let me just step back. So the purpose of the act is to encourage and promote collective bargaining, and so right. There's a bias towards the parties working these issues out themselves. And as a practical matter, that's what they do. And so the question of whether, for example, an individual employee, to use the board's example from the reply brief, mechanics in a broader unit, should or should not be included in the unit, typically is, I mean, there are other mechanisms, but typically is resolved by the parties in collective bargaining if the inclusion of those, I think their example was 3 or 5 mechanics, is not determinative of the outcome of the election. And that's always been how as a practical matter it's worked. And I think part of what goes into that is the thought that the employer and the union are bargaining about the relationship around the bargaining unit, and that individuals come and go. People leave employment, come to employment, and their particular status, depending on who the person is, may change. But what's really at stake ultimately in the bargaining is a definition of what the bargaining unit is and who is in and who is out.
But aren't there employees whose status legally preclude them from being included, like a manager or a supervisor? And if there's a dispute over whether, let's say, cashiers are managers, and the union gets voted in and the employer just says, I got other fish to fry, this way at least I'll, be able to communicate with a broader number of workers through these pesky union representatives, and they skip over that, then you're really having union representation for people who are not legitimately covered by the act.
That is a possibility in the universe of possibilities. I think in most cases, the parties agree to exclude supervisors because obviously if the employer really wanted to go to the wall on the issue, they could go to the board and have them declared ineligible. But again, what is at stake?
Can individuals go to the board and say, I am a supervisor, I shouldn't be included, or is that something that's only for the board to do?
The parties would, I don't believe there would be any standing for an individual to go and say, I shouldn't be in a bargaining unit. So what's at stake here is that the board has interposed a new process, a new requirement that the petitioning party, oftentimes the union, must show in order to get to the election. And not only is this actually a substantive requirement that the union has to overcome to get to the election, but the board actually justifies the provision on a substantive basis. And this echoes what Judge Pillard, you were just referring to, saying that this is important because we have to resolve issues of supervisory status before the election to know who speaks for management. That's an issue of how the parties communicate with voters. And I guess I'm not here to say that might not in certain circumstances be an important issue to resolve, but that is a substantive basis for this change, and one that ought to have been subjected to notice and comment. How the board goes about determining when it is important to decide these issues prior to an election.
We have a certain perspective, and I'm sure it's distorted since it, as the briefing emphasizes, only 10% of elections go forward other than by agreement to procedures. But we've had cases that we're litigating, for example, the question of who's a supervisor. And they took years, right? Because they go before the board and they go to us. And so in a case like that, under this rule, would the election be on hold for all that time?
Potentially, and that goes to the interplay, and maybe that's a good segue for me to move to the certification rule, which relates and which the court has asked my friend about as well. So, the certification rule.
Before you,
okay.
I think this will facilitate the transition too. I think, but our decisions on the drawing the line between procedure and substance in this context, I think, recognize that it's not a black and white principle, that there's fluidity there and you have to take into account some contextual considerations. But one common recognition is that procedural changes can beget substantive consequences, but that still doesn't make them non-procedural. And the easy one that's substantive is when the ultimate substantive standard is in fact changed. Everybody agrees that's substantive. And both on the one that you just talked about and the one that you're going to talk about, I don't think the ultimate substantive standard changed because the standard for issuing certification still remains the same. Now, the fact that certain issues have to be worked out in a different temporal space can have substantive implications. But the question that is in my mind is, how do we know whether this is a procedural change that has, because I think everybody also agrees that you can call these procedural changes. And then the question is it a procedural change that doesn't involve a change of the substantive standard, but still has the kind of substantive effect that would render it categorized as substantive rather than procedural? Because what you said so far, I think, still doesn't deny that the substantive standard at the end of the day didn't change. What you're sort of saying is that this has substantive implications, and from your perspective, important ones. And it's just, for our purposes, we have to figure out whether those kinds of substantive implications are enough.
Yes. Okay. So I'm gonna quarrel a little bit with the question. I do think by requiring the board to determine individual eligibility issues in all cases, that is a change to substantive standards, because as I've explained, in the vast run of cases, those individual eligibility issues, when they're non-determinative, which they typically are, not always, but typically are, never are resolved by the board. So now they've said, you must do this. This is something new that was not true before. But even if I were to accept your premise that could be categorized as a procedural change,
because I think procedural changes, and it's just true that sometimes there are procedural changes that result in issues being decided that may not have been decided before, because it's still a procedural change. Any timing issue can mean that an issue that would have been decided before isn't going to be decided now, because somebody might be out of time under the old rule but not under the new one, or vice versa. And
I don't want to quarrel too much, because I'd like to answer the other part of your question, but I will just a little bit more, which is that if the board were to have said, before any election, we will order any election, we must determine the status of anyone the employer alleges to be a supervisor, I would argue that was clearly a substantive change. It exists nowhere in the law. It's not about timing. It's about a substantive determination that must be made as a prerequisite to the election. And as I read the board's rule, that is in effect what they've done here. They say these individual issues must be determined before, and give specifically the example of supervisors. So I'm quarreling. But to go to the second part of your question, the reason that even though one might characterize some of these provisions as procedural, seen in a certain light, why they are substantive and subject to notice, should be subject to notice and comment rulemaking, is because they all involve the primary conduct that's regulated by the Act. So this is not about the, the timing of when a request for review must be filed, or how many pages may be filed, or whether a response is permitted, which are sort of the secondary aspects of the board's election procedure. These are the primary aspects. These are, can you get an election? What must be determined to get an election? When do you get the voter list, which provides the union, as the Supreme Court has said, with the equal access to speak to employees that the employer already has? What is the time period for campaigning between when the decision for election issues and when the election takes place? These are all the primary aspects of the process under the Act.
Can you explain why 3 days on the voter list makes a difference? I understand that you care a lot about it, but from a distance, some of these, I have the impression from both parties that this is a much more, intensely fought terrain than one might think. And it just, at least I would find it helpful to understand a little bit more about why that is.
Yes, so.
Not just the 3 days, but for example, the timing of the certification of election results as well.
Yes. So on both, I'll take those in turn. So on the voter list, so obviously, as has already been said, the employer has full access to the employees. What the employer may not know until soon before the petition is filed is that the employees are organizing a union. So as soon as that trigger occurs, the employer has the ability to campaign amongst its employees up and running, whereas the union is always playing catch up. And so you're talking about within a limited time period of the election campaign, the ability of the employer to get out ahead of the union in terms of communicating its message to employees. And in that sense, it's extremely significant. It would be as if in a political election, one party said that you can't start campaigning until 5 business days after the other party. We would, I think, all see that as being a significant impingement of the right of one party.
Mr. Ginsburg, as you pointed out, the union has the advantage sometimes before the employer, in terms of the employer may be unaware that employees are moving to organize or to unionize, right? So there's a different advantage for the parties at different points.
Again, not to be quarrelsome, but so the purpose of the voter list principally is that very typically the union does not have access to all of the employees or how to communicate with them. So they may have limited access, depending on the workplace, coming in and out of work, or there may be whole groups of employees who the union just isn't aware of until the list is turned over to the board and then the list is turned over to the union. So I take your point. I mean, the union obviously, in order to file a petition, has to be speaking with some of the employees, but to win an election, you need a majority. And as the court recognized in Wyman Gordon way back in the 60s, it's just given the structural setup for the union to have a fair opportunity to talk to the employees during the campaign period, they need this voter list. It's extremely important.
Can you also speak to the question? So with the election observer rule, can you, on your view, does that change affect the union and the employers in a different way? Because it seems like a rule that applies equally to all parties. And I'm just wondering if you think that there is some kind of differential impact on the union from that rule. Because I think under some of our cases, at least, when a procedural rule has different impacts, that can be a reason for considering it to be substantive.
So without getting too far into the weeds, it does, and it does in different settings. I mean, the issue of whether or not the union can have a non-unit employee oftentimes comes up in elections where the employees are very scared to sit up there at the table and be visible with in front of the employer and its management. And so having the opportunity, for example, to have a former employee, someone who perhaps was, left prior to the organizing campaign, or in some instances, a union staff member, makes a difference and sends a message to the employees who are voting that this is a fair election, that both sides get representation. But I think the main point is we would have things like that to say to the board if they had put this out as a proposed rule for notice and comment. It is in fact a very detailed area of the law, of the board's law, but to just change that important substantive part of the election procedure. I mean, it's the final, it's the employees coming in to vote and who they see representing each party without even asking for notice and comment from the parties was the violation here. I know my time's expired. If I could quickly speak to the certification issue.
Yeah, please.
Okay, so the issue with the certification is that by telling the regional directors that they cannot certify the election results while a request for review is pending, deprives the union, firstly and most importantly, of the statutory right to bargain with the employer. That right under the statute attaches when the union is certified, and of course that's what this is all about, is the opportunity to bargain with the employer. So that's a right that can be enforced under the unfair labor practice provisions, and so by preventing that, it pushes that down the road, and that's extremely important because it's hard to bargain a first contract. Employees are scared. They're looking to the union to see whether the employer is going to deal with the union, whether this was actually something worth fighting for, and whether at the end of the day they're going to get an enforceable agreement. So pushing it off.
Does it prevent it? Because the argument that the board makes is the employer is always at risk in this situation. So it doesn't actually prevent it, because if the employer doesn't, then it's at risk at the end of the day of being found to have been in violation.
So I apologize for to delve into the weeds of the doctrine, but they're very important weeds, particularly on this point. So the board is speaking of the duty to not make unilateral changes to existing working conditions, and we agree that attaches at the time of the election. But this is about bargaining a contract. This is the going forward, why people organize the union, and that right attaches at the point of certification. That is a different right. That's the key right in the statute. And so by pushing that down the road in every case, automatically under this rule, that is a substantive change to the basic right that's protected under the Act. I wanted to just quickly address the 8B7, the unfair labor practice for recognition and picketing in aid of bargaining. The argument, and I would just draw the court's attention to the text of 8B7 itself. That is a prohibition against unions. It says you may not picket in order to require an employer to bargain with you, the union, unless you are currently certified where there's been an election in the previous 12 months. And so our point is that a union who is certified and the employer refuses to bargain can put up a picket line and say, come on, you got to bargain with us. They can exercise their collective power to get the employer to the bargaining table under the clear text of 8B7. But if the union is not certified, because there's been an election held in the prior 12 months, they are prohibited by the plain language of 8B7. The cases that the board cites are cases that have to do with recognition picketing prior to the filing of a petition. Those are different cases. They're not on point. So our only point there, our primary point has to do with the duty to bargain upon certification. That's really the meat of the matter. But I did want to clarify.
And it doesn't cure that that if you bargain, that whatever terms you get would then date back. Do they date back to the time of the election?
No. I mean, no. I mean, the employer, I suppose, theoretically could agree to that, but that's not typically the practice. No, and again, it's both that literally the employees are not getting the benefit that they would achieve through a collective bargaining agreement, but it's also that it is very difficult for a union to maintain the cohesion during that period if the employer can be going around saying, well, you're not even certified yet, we don't have to bargain with you yet, and that drags on and on and on. That's why certification is so important.
So on the recognitional picketing, just to back up, you said that you can't picket unless you're currently certified, and that the cases that the board refers to about the pendency of a representation petition don't apply after there has actually been an election and before it's been certified?
That's correct, and that's 8B7 subsection B. So it's a different subsection of the statute. I grant you this is not something that is, is prevalent in the case law, but it is in the statute. It is a right in the statute, and it goes to the fact that it's all keyed to the fact that certification is so important in order to commence bargaining.
And the unfair, so you had, I think there were 4 categories. You talked about unilateral changes, unfair labor practices, recognitional picketing, and bargaining, and maybe in the bargaining being the most important. And there's just no duty, to bargain, and any results of bargaining don't come into effect until bargaining has concluded.
That's correct. And I would really emphasize that is the key point. And just to go back to what the board in the preamble said about the rule, is they said this rule is all about shifting the risk from the union to the employer. We don't think the employer ought to have to bargain if there's any with the union if there's any possibility that the decision might later be overturned. Of course, the flip side of that is that the union then is not entitled to bargain with the employer. And throughout, the board acknowledges it's
I think you said it in a reverse way. It's shifting the risk to the union from the employer.
Yes, if I may have misspoke. Yes. So shifting, yes. My time is up, so I don't want to. I'm happy to address the 3B point and others, but I don't want to overstay my welcome.
Make sure my colleagues don't have additional questions for you. Okay, thank you, Mr. Ginsburg. We'll hear rebuttal from the board. Mr. Thomas, I think your proportional allocation is 1 minute.
Yes, Your Honor, although I note that the union didn't really make any particular points in its argument, so I would just open the floor to the panel if there are any additional questions on the jurisdictional issue.
I guess I had one for you, Mr. Thomas, which is how is Section 10F ambiguous in any relevant sense? If it were ambiguous, then we read it in favor of going directly to the Court of Appeals. What is the argument that it is ambiguous, though?
The reason why it's ambiguous is that the key jurisdictional section of Section 10F speaks only to a final order of the board granting or denying the relief sought. It does not require that final order be in the context of an unfair labor practice proceeding. There are, as we said, surrounding implications in the text and where it's located in the statute that might sort of imply that it applies to unfair labor practice cases, but the text itself, the key sentence there, does not limit it to unfair labor practice orders, and that's why we believe it's ambiguous.
It seems, I mean, it's a little tricky, and maybe you can help me think this through, but it seems like the default rule is that you first go to the district court, and that's just as a result of 1331, and we don't lightly remove jurisdiction without a clear legislative directive. But then we have this overlay rule in the New York Republicans case that says, where there is a directive that you go initially to the Court of Appeals and there's sort of ambiguity about the scope of it, you read it amply. And so I guess you're saying, so how do you get over the first of those, though? It seems like ambiguity isn't enough to overcome the default rule that people seeking review of agency action go first to district court.
So it might be helpful to think of it in kind of terms of, for instance, sort of a burden shifting statute or presumption shifting situation. So the initial presumption is that parties go to district court unless there is a provision in the statute that provides for direct review in the courts of appeals. But there's no dispute here that Section 10F is such a provision. It channels review of final board orders, certainly at least in the unfair labor practice context, it channels review to the courts of appeals. And the only question is how broadly to interpret the scope of Section 10F. In that situation, in the situation where the only question is how broadly do we interpret the scope of a direct review provision that everyone agrees exists, the presumption is that the direct review statute applies unless there's a firm indication from Congress that it should not apply to a particular category of cases.
Okay, thank you, Mr. Thomas. Let me make sure colleagues don't have additional questions for you. Thank you, Mr. Weiss. We'll give you 3 minutes, and if I could just ask you to make sure to address the point emphasized by the AFL, Mr. Ginsburg on behalf of the AFL, that would help me to understand the response to the point that the duty to bargain kicks in on certification, and that's what's largely at stake here, and that's why the shifting the certification has a significant substantive consequence, because there's no duty to bargain in the absence of the certification to begin with.
Yes, Your Honor, certainly I'd be happy to respond to that. I think there's the most immediate response to that point is that a employer, so looking at the position of the employer in these cases, so this issue comes up when an employer has filed a request for review challenging the validity of a bargaining obligation, and so, or of a certification, excuse me. And in those circumstances, as the board notes, it doesn't make sense for the agency to enforce a bargaining obligation that presents the exact same issue that is being presented in a representation case. And so as the board explained, for purposes of ordering its litigation and not having an unfair labor practice case raising the same issue as a request for review being present before the board at the same time, that simply as a matter of administrative convenience, it makes sense. An employer who has filed a request for review contesting a bargaining obligation, it's simply irrational for them to bargain with the union while that request for review is pending with regard to the bargaining obligation. And with respect...
Wouldn't those two cases, the unfair labor practice of, could you have a situation in which you have one case going to district court and one case going to court of appeals that are raising similar issues? The employer refuses to bargain, no, because there's no obligation to bargain under your rule.
Correct, Your Honor. And I know both of those issues in the first instance are going to come before the board. And so from the board's perspective, as it explained in its rule, it's simply, along with, removing the confusion from a certification that would later be revoked, it simply, as a matter of administrative convenience and orderly litigation, makes sense to decide the issue in the representation proceeding, as opposed to allowing unfair labor practice and representation proceedings to proceed parallel to one another. And I think tying back, outside of the bargaining context, I think there's a couple other points to make in response to the certification issue. The first is that outside of this specific bargaining obligation, virtually every other meaningful right that attaches to the union representation issue goes back to the election. It's not just limited to unilateral changes. As we've indicated in our briefing, there's other rights that attach, such as the right to request information, other important, I'm blanking on the other issues, but I know there are several others that we addressed in our briefing. So it's not simply the obligation to refrain from unilateral changes. There's many other substantive rights that flow back to the date of the election, regardless of when the certification issues. And as the board explained, issuing a certification while a request for review is pending is simply confusing, because the board could turn around and revoke that same certification later. And that was a situation that had come up in several cases.
Do we have any sense of the win-loss rate of these challenges? I mean, there is a waiting game, especially in low-wage work where there's a lot of worker turnover for, it may be advantageous with a very slim case for an employer to challenge representation. And, just make the employees who stuck out their necks to vote for a union, feel like, and what did I get for it? I'm not seeing anything, months go by. Does the board have any sense of sort of, on average, how often these challenges to representation succeed?
I don't have that information, Your Honor.
And that's not in the record of the rule at all?
I do not believe so, Your Honor. What is in the record is that the prior rule changes of a similar nature have not affected the union's win rates in elections and achieving certifications.
Right. But I took you to be talking about not the win-loss rate, but the confusion from a certification later revoked. And the question I have is sort of, well, does that happen a lot? Is that a big problem or not? And there's not anecdotal or descriptive information about that.
I believe that's correct, Your Honor. The board was exercising its institutional expertise in terms of, making a policy judgment about.
But you're not aware of the grounds for that expertise, the substantive thinking behind that, other than the logic of it that you recounted.
Well, it's the logic and the explanation that the board has placed in the Federal Register, and obviously the deference that is due to the board in these areas. And if I may just respond very briefly on two more points. The first is with regard to the litigation of status issues in the pre-election hearing. Just a couple of brief points to highlight. The first is that oftentimes these issues actually do come back before the board through what's called the unit clarification procedure, where the parties are unable to resolve the status of individuals. Then that issue simply comes back before the board. And so a lot of the board's motivation in making this rule was to just decide those issues up front and not have them hanging around and having to decide them later. The second point that I want to raise is...
Who filed the unit clarification, either the union or the employer?
It could be the union or the employer, and I've handled these, and even employees will file them in some situations.
Oh, okay.
Yeah. And then the second point is just to correct another brief mistake by opposing counsel, which is that these rules this rule doesn't require litigation of these issues in every instance. As the board explained, it's a normal, it instructs the regions to normally litigate these issues, but also gives an option for deferral. And the converse was true under the 2014 rules, that the issues were not always required to be deferred, and that regions had, the regional directors had the discretion to have these issues litigated in certain circumstances. And then the final point I'd like to push back on briefly is the primary purpose argument that my opposing counsel made. In particular, I would direct the court's attention to a series of decisions involving the FCC and radio application cases, in which the rules at issue were dealing with the denial of radio or TV application licenses, such as Ranger v. FCC, Neighborhood TV v. FCC, Kessler v. FCC, and that's obviously one of, if not the primary duties of that agency. And so I don't think that's a meaningful distinction under the law of this circuit. And then the last point I'd like to make very briefly, with regard to the 3B argument and the space between, to the extent that there is space between what we've argued and what the board wrote in their rule, you'll notice in the briefing that this was never an issue that was addressed in the lower court. And what I'm talking about in particular is the alleged space between what the board said and what we said in our briefing. We never addressed that issue because it wasn't raised until respondents' reply brief. The lower court made a Chevron Step 2 finding. We've argued Chevron Step 1 and 2 throughout our briefing. And the only time that respondent made this argument was in its reply brief, in the final briefing in this case. And so we haven't had an opportunity to brief this case. We believe that it's waived under this circuit's precedent. I apologize for not raising that issue earlier, but I'd just like to flag that for the court as my final remark, unless there's other further questions.
Okay. Thank you, Mr. Weiss. Thank you to all counsel. We'll take this case under submission.
This honorable court is now adjourned until Wednesday, the 19th at 9:30 a.m.
Goodbye.